All right. So we are August 10th, 2020, 6 p.m. Eastern Standard Time. This is the Boca Real Estate Investment Club's, I believe it's our sixth meeting of this class for 2020. And tonight we have two guests that are on this Zoom meeting. My neighbor, friend, and attorney, Steve Sorrell.
Hi, everybody.
And my newfound friend, eviction master, Jaron Kelly.
How are we doing?
He is the king of evictions. Get it
I
right.
like to say the emperor of eviction.
I've heard him referred by not only attorneys, but by investors and property owners as the ticket clinic for evictions. So just high volume, churn and burn, get them done quick and affordably, which is great. What we're going to discuss tonight, a few different topics. We're going to speak with Steve about writs of possession, re-foreclosure process, and quiet titles, which some of you newer investors have no clue what any of that is. And some of the more experienced investors, you'll still learn something from this, because I can tell you in 20 years of buying, selling, trading, renting real estate, I don't even understand these things and the complexity, and nor do I really care to, but I do care to have experts that do, that I could simply hand the file over and they handle it for me. Jaron's going to be talking about the eviction process, what's going on with COVID versus standard evictions that we've experienced for the past God knows how many years, and how things have been completely thrown for a curveball since coronavirus really came into our lives. So hang on one second, guys. Let me close the door. Sorry to do this.
Technical.
Yeah, doing this, it's great that we have the technology to broadcast live from anywhere in the world. It's not great when you have two kids fighting in a hotel room. But all right, so let's start off with Steve, right? And the whole point of tonight is to go over what happens after the auction. So we taught this class on buying properties, preparing to buy. What happens once you bid? What should you be aware of when you're bidding? But there's so many things that people aren't aware of that happen after the fact. After you get that green light that says, congratulations, you're the winner. It's not just, here's your house, pay for it, remodel it, sell it, and make money. There's very often, I'm going to say with 90% of the files, there's some legal aspect that we need to be aware of. And very often that's the writs, the evictions, problems with the foreclosure that happened that we weren't aware of, or maybe sometimes we are aware of. And Steve's a guy that for the past 10 plus years, pretty much when I buy a file that has any problems, any hair on it, I don't even want to know. I just hand it to him and I say, fix it. And from there, Steve, why don't you take it and go over some of these three processes: the writs, the re-foreclosure, and the quiet title.
Thanks, Marshall. I appreciate it. Yeah, we're pretty much a full service real estate law firm. We do a lot of closings as well as, litigation work. So, I get really surprised when someone sends me a file that's clean. We've been fixing files, these dirty files since, the crash in 2008. And there seems to be always a problem with it just because of the volume that we were seeing in 2008, 9, 10, 11, 12. The lenders who had foreclosed, they were forgetting to name defendants. They were putting the legal descriptions incorrectly into their, into the foreclosure complaint. Or sometimes, the deed itself or the mortgage itself would have an incorrect legal description on it. And instead of invalidating the entirety of the foreclosure and losing your property and vacating the sale, there are certain mechanisms that we can do, be it a quiet title action or a re-foreclosure that can correct some of these defaults. So some of the biggest defaults that we see in a foreclosure is, like I said, they omitted a junior lien holder. So let's say there's a second mortgage on it. That mortgage, wasn't named, is not extinguished, even though it should have been. And now you're holding this property. You want to sell it, but there's $200,000 equity line of credit that was never listed on the foreclosure. So what we'll do is we're gonna, we'll file a re-foreclosure complaint. We'll name the omitted defendant. it's a process that takes roughly between 3 and 6 months is what I've seen, and how we've been able to handle it. You have to, serve the omitted defendant and a few of the other defendants that are on there. That's generally the main thing that I've seen with re-foreclosures and problems with the foreclosure process. The other one is the title defects dealing with the legal description. I'm doing one right now where, going back to the warranty deed in the 80s, it was a condo, but all the legal descriptions describe it as plats, which is incorrect. That's only with homeowners. When you have like a homeowners association or a home, it's described as, plat, 6, block, 8, section 2, or whatever it may be. So we had to go back to the warranty deed, and then every single document from the mortgage and note to the list pendants to the final judgment had to be all changed. And the investor I was working with was very, very scared that the whole thing would be vacated. But luckily, we're able to fix a lot of these mistakes, and you get your properties and you're able to flip them and sell them and make money. The quiet title process is an interesting process. I'm not sure if, Marshall, you've talked about this before, but have you talked about the tax deed sales?
No, it's something that quite a few of these investors that join this class have asked about. And if you want to touch upon it, by all means, go ahead.
I'll just very, very shortly say that essentially, if you don't pay your property taxes, the taxes after 3 years turn into a certificate, or I'm sorry, after they become delinquent, they turn into a certificate. They're sold like any other, let's say a bond or a municipal bond. They have a certain interest rate and they mature for a 3-year period. And after that 3-year period, they get sold on the auction like it would be a foreclosure, and then you're able to pick up this property. Some of the issues that I've seen, and especially when you're investing in tax deeds, what is a great thing about them is that mortgages, they are extinguished. Association liens extinguished. Junior judgments, everything is extinguished essentially except for governmental liens. So if you're looking into it, just make sure that you talk to someone like Marshall, or someone that can get you the information, so that you're not buying a property for $40,000, $50,000 and thinking you have this great thing, and then you realize that the person hasn't cut their grass in 3 years and has been accruing a $100 fine for a 3-year period, and now you owe $300,000 to the city of Boca Raton.
Now, Steve, let me ask you, for the investors present here tonight, and for the record, so I've had that before. Let's just say the city of West Palm Beach bought a property and it had $350,000 in non-grass cutting liens.
Yeah.
What would you say is the likeliness that a city will negotiate post-purchasing at a tax deed sale?
My experience has been pretty good. I mean, I dealt with a few pricks for the cities and the counties, but generally speaking, if it wasn't your violation and you go and you show a good faith effort, say, listen, I bought this property, I'm going to fix it up, I'm going to make it resellable, I'm going to increase the value of the neighborhood, of the community, of the city. A lot of these charges are just a daily fine of $100. A lot of times they will reduce the amount to 5% of the lien or 10% of the lien, based on the fact that you guys are really trying to do the best for the city and county. So that's been my experience, but it's a hassle. You have to go to the city or county. You have to file for a lien reduction hearing. You have to go in front of the board of that city or county and ask them for the reduction.
And now, one thing I want to say to the group also is, I've found that when it comes to these lien reductions, if you go with an attorney, it actually works against you versus going on your own and representing yourself and saying, hey, I bought this property, I'm going to improve it, I'm going to make it better for the neighborhood and for everyone else. How do you feel about that? And I know you're an attorney and it benefits you to be there, but in all honesty, for the investors that are buying for the first time, would you
well, first of all, thanks, Marshall, for throwing me under the bus and taking money out of my pocket. I appreciate that. But no, he's right. If you get a fancy attorney in a suit to go there, I mean, it depends on how aggressive the board is. But I always tell my closest friends and investors, put on a polo shirt and some jeans. Bring your assistant if she's really cute. Go talk to them. And a lot of times, they're just people like you and me who are volunteering their time on the board. So, you will have, generally speaking, better results if they don't think you're aggressively coming off with an attorney, And B, oh, this guy has money. He hired an attorney. He must be able to pay, 50% of the fine. So, if they see that you're just, a regular person trying to do a flip, they'll, a lot of times they'll reduce it down to 5% or 10%. That's what I've seen at least.
And by the way, it was a loaded question because Steve was the one that actually a few years ago suggested that I go to the city on my own and negotiate, and it worked out great.
Good.
Mind if I chime in here real quick? So we've done a good amount of these fine hearings, and while I agree with you, Steve and Marshall, to an extent, what I recommend at a minimum is you go to someone, for example, like Steve, and work out what your arguments are and what your case is. What kind of case are you making to the city? Because there's different types of evidence and different types of reasons. Like I've had situations before. Certainly it's a little easier when you're a new investor and you purchase a property at an auction. It's a completely arm's length transaction. You are trying to improve the neighborhood, just like you're saying, Steve. But if, for example, maybe you're a homeowner or an investor that didn't get a notice of a fine here. I've had investors that live in Israel or they live in some other country and the notices didn't come to the right address, or maybe there was a property manager that was not doing their job, or the notices were going to a PO box that no longer was functioning. I've seen all kinds of things. I've seen the city made mistakes with notifications as well. So just make sure you've gotten your arguments buttoned up, and coming to an attorney such as Steve, at least take your notes, and even if you need to spend a few bucks on a consultation, do that. And then if you want to go on your own, then that's fine. But I wouldn't recommend going in unprepared. That's the point.
Yep. So definitely consult with an attorney for advice, but don't bring the attorney with you. Is pretty much is what I'm getting from that.
Hey, Marshall, one of the things that we had one time where we got screwed over really badly was when we had the property listed and it showed as pending on the MLS, and they did the math. So I guess the code enforcement officer did the math, and they figured out what we were probably making on the property. And when we got in front of Gary Brandenburg, he said, I'm tired of you, investors trying to think that we're just going to take it down to like 5 or 10%. And he left a large chunk there that we did not expect. So
that's a shame. Every once in a while that happens, and different cities are different. We had a not so great result at the city of Palm Beach. Obviously, there's more people. They expect everyone has a bigger pocketbook. City of Riviera Beach is normally pretty bad. Their code enforcement, and sometimes their fine and lien reductions are not as good as other places. But some cities we've had wonderful results with, Boynton Beach and Palm Beach County and a number of others. So I don't know if you agree with me, Steve, but everyone's a little different. Sometimes it can be very arbitrary too.
Yeah, Riviera has been consistently a problem for me. That's the only one that stands out. Is I won't even touch Riviera because of that. Yep.
And they've had some nightmare code enforcement officers. I don't know. There's one gentleman there who's notorious, and I don't know if he, I use gentleman loosely. I don't know if he's actually since retired. I heard he was on the verge of retiring, but he was an absolute nightmare to all of my investors. They hated investors, and seems like that's one city that really needs a lot of investors and cleanup. So, yeah.
Yeah, I mean, don't forget, you guys are doing a service, and that's what I like to, instill, when you're talking to these people, talking to these code enforcers, really kind of beat that into them that, you're not here to, yeah, you're going to make a profit. You're not doing it altruistically as charity, but at the same time, if there's no incentive to go and buy these properties, then these properties are just going to sit there and languish and make the cities and counties, a shittier place. So you're really doing a service for them by cleaning them up.
And definitely use that legal term, shittier place. You learn that in law school. It's Latin. Yeah.
All right. You guys there?
This is dead people. So a lot of times what happens is you're going to find someone that has been deceased. And this is something that me and Jeron's firm have worked kind of closely with sometimes, especially with quiet titles. What you need to do is you need to have a guardian ad litem appointed who is a separate independent attorney. And I've had, someone at Jeron do it for me, and I've hired him, and he's hired me to do a couple for him as well, to go out and find the heirs, the unknown heirs, and the people who are below, someone died. And quiet titles being defective, where someone has just died and no one picked up on it. So, you know, they foreclose somebody out and the person's been dead for, you know, 4 or 5 years, and we have to go back and re-foreclose and get a guardian ad litem to represent the interests of the unknown, a writ of possession under the quiet title. So the quiet title statutes, tax statutes are under 197. And if you look at 197.562, it actually grants the tax deed holder immediate possession. So on its own, it's not not such a forceful statute. You can't just, you know, buy a tax deed and go and you know, bring this to the person that's living there and say, now it's mine, get out. But if you already have a quiet title action going, you may be able to use that, you know, particular provision, or if you have an unlawful detainer going, you may be able to use that particular provision to get the person out. So I just wanted to talk about that. I'll let Jerron talk about writs of possession and the eviction process, because I know that's a lot. You do a lot of that. I don't do any evictions, but I do writs of possession, but it kind of goes hand in hand together.
Sure. If you want to, go ahead and cover the writs, the on foreclosures, and then I'll take it from there.
Sure. So you know, once you get that certificate of title, and there may be obstacles to getting your certificate of title. You know, there may be an objection to sale. There may be, you know, other defects that will prevent you from getting title, and I can, you know, obviously help with all of that. But once you get title, generally speaking, both the statute and the final judgment will give you the right to get possession, get a writ of possession. What that entails is entering into the foreclosure process as a quasi-interested party. You as a third-party purchaser are now an interested party within this foreclosure, or quasi-interested, and you have the ability to ask the court through a motion for writ of possession to grant you possession. You'll have a hearing, so you'll probably have to go for a hearing in front of the court. You'll have the hearing, hopefully you'll get it granted, and then you actually need to have a writ of possession itself that will be stamped by the clerk, sent to the sheriff, and there's a $90 fee that's associated with the sheriff actually going and enforcing that writ of possession. It's a pretty straightforward process, but it is fraught. I mean, so many times where I've seen a defendant come back after we got rid of possession, and they do a stay to the execution, and they say, oh, I can't leave, I don't have the money, and you have to go back to court again. We try to, you know, streamline all that process, but it is one of your tools and one of your greatest tools in order to get someone out following a foreclosure process. And you know, it could be faster and less expensive than doing a traditional eviction, which you may not be able to do when you buy it from a foreclosure, based on the fact that there was no lease agreement.
Steve, one thing I want to walk, especially the new investors that are here that have never done this, as far as they've never bought a property at auction. So they win the property at 10:30 in the morning. What's the first thing they should do once they win?
Celebrate?
Yeah, celebrate. And then I typically, for instance, I run out there with a notice. It's not a 3-day notice, but I put a notice in the door identifying, hey, I purchased your property at auction. And it's a very friendly notice too. I want to introduce myself. My name is Marshall Sklar. I've been buying properties in this area for 20 some odd years. Here's my cell phone. Here's my email. I know these times are very challenging for you, so please understand I'm going to work with you. And I highlight that and I hand sign it and I deliver it to their front door. I knock first. And I always, by the way, when you knock on someone's door that just got foreclosed on, don't stand in their face. Knock, take 10 steps back. If they don't come to the door, put the letter in an envelope with their first and last name and leave it. They don't want it publicly known in case FedEx comes to their door, or who knows who else. Yeah. And also, you never know. I've had people that I've heard stories, they come to the door with a shotgun. They don't know who you are. They think you're the sheriff or you're the bank.
It happens.
So I always stand back.
No, that's really, really good advice. And one of the things I like about Marshall, opposed to some other investors I work with, is some investors will say, Steve, you handle it and go and, you know, do what you have to do, get them out. And it's very impersonal. I like that, you know, most of the time, these are just people, you know, and they're going through a hard time. So if you're able to establish a relationship with them and talk to them, you may be able to get them out of the house faster and you know, with less cost, just by talking to them and seeing what they need. And if they're willing to leave peacefully, if they need, you know, an extra 2 weeks to get their affairs in order, whatever it may be. And that's one of the things I like when, what Marshall does is he'll go and talk to them and see if that is something that they can work out. And if they can't work it out, then he needs to get attorneys involved and go from there and do the process. But just so you know, once you buy it, the next day they should be issuing, the certificate of sale either that day or the next day. And then any party, to any defendant, has the ability to file an objection to sale, which would stop the issuance of the certificate of title, which means it would stop the conveyance of title to an investor that bought it. So you put all this money into it, you paid it, you have $300,000, $400,000 in the clerk's registry that was taken and paid for, and now you're stuck because someone filed an objection to sale. When that happens, what we need to do as attorneys is set that objection to sale for hearing, do a memorandum or motion, either to issue certificate of title or also do a memorandum in opposition to the stay or the objection. It really can only be objected to on certain grounds that, that there was some sort of irregularity with the sale process, something happened with the software that was wrong, or that it was just grossly inadequate. Let's say you buy $1 million property for $1,000. That's a grossly, low amount that you would be paying for. So aside from those really two instances, there really should be no barring, unless maybe there was a bankruptcy filed or something along those lines. You should be able to get your title. So that's also important when you realize that you're not going to get your title right away. It's going to take at least 10 days and maybe longer to get your title.
So Steve, just to go back to the initial question about the process. So I win. I post my nice friendly notice, or I hand them the friendly notice. Within a couple of days, I typically arrange to meet with them. And I use Forewarn, the software that I can put in someone's name and find their cell phone number. I call them, I reach out to them if they don't proactively reach out to me. And I have a document that has language that bars them from objecting to the sale. In return, I grant them possession for a set period of time.
Yeah.
I got to tell you guys, and Steve, as my witness, in all the years of doing this, I've only had to actually follow through with one eviction. That's the crazy lady in Boynton. Got struck by lightning 3 times in a month. Yeah, we won't say any names here, but we had one case where she claimed she got struck by lightning, and that's why she couldn't get out. Meanwhile, it was crazy.
I saw her Facebook picture, and you know what? She actually may have been struck by lightning.
I agree, or maybe stuck her fingers in the electrical sockets. But
yeah.
So I'm going to share these documents with you guys. But that being said, Steve, is it necessary to post a 3-day notice or any type of statutory notice when you're going to follow through with a writ post-auction sale?
There, I would say, it's not like an eviction in the sense where there's a 3-day notice. But you do need to notify, or it needs to be, they're going to be notified by the final judgment, and they should have been notified. I mean, it's in there, it's in that document itself. So I think it's best practice to do what Marshall's saying. I think contact is the best way, especially if you can do a resolution and you can come to an agreement where you have the person, sign something saying that they're not going to object to sale, that they're going to leave on their own volition, and that you're not going to need to hire an attorney to do these sort of actions for you.
Perfect. Okay, and I'm telling the group right now in the text, guys, I'm going to share this form that I use with you, which is something that I've perfected over the years. It's still not perfect. We're always improving on it, but we have a form that we get them to sign, or we ask them to sign, and basically it's a quid pro quo. I'm going to give you 30, and I'll even go up to 45 days. Sometimes it actually works out better for me while I'm pulling permits for the job or shopping product for the job. My agreement allows me to go in, work on the house as far as necessities. So if the roof needs replacement, it allows me to remove the roof. It allows me to pressure wash the exterior, redo the landscaping to be in compliance with the city or county or HOA. But at the same time, they have a place to stay for 30 or 45 days. And I've even, it's probably been a dozen times now, I've helped people relocate. I've had a few cases where they had enough equity in their home and there was surplus funds from the auction where we went and helped them purchase another home for cash after the auction, but a much less home. For instance, one that we bought in Boynton for $250. The guy had like a $40,000 mortgage. He got a check for $200,000 from the courthouse and went and bought a place in Century Village for $110,000 cash. And we represented him on that. So if you approach these things the right way, from a brokerage standpoint, you can really kind of double dip and you can help accommodate these people without throwing them out on the street.
And you probably want, I actually want to ask Ron about this because he probably knows better than me. In the eviction statute, is there, it kind of comes and goes when it comes to the writs of possession. I know there was a provision where you had to give the tenants, 30-day notice after foreclosure, and then that expired, but then it came back again. So maybe you can touch upon that.
Sure. Yeah. So there's a couple things going on without diving too deep in the weeds here on this. But what we do as a practice with our firm, when we get someone that purchases something at the foreclosure auction, you send us the file, you fill out an intake, and then the first thing we do is send out a 30-day notice form, which is under Chapter 83 of Florida statute. That's the Florida statute for terminating a tenancy from a foreclosure property, a property that was in foreclosure. So it's kind of, because you have state law and then you have federal law over it. So we do that for the state law just to cover our rear end, but it's also a way for us to give a period of time for them to produce a bona fide lease if they have one. Because if they have a bona fide lease, then federal law says that you have to honor the bona fide lease as long as the bona fide lease is for market value. So good faith market value. So meaning, you've got someone shows you a lease and it's $800 for a 3-bedroom house in Boca Raton that should be renting for $2,200. That's not a bona fide lease. And then if it's between, let's say the defendant in the foreclosure was Joe Smith, and it's between Joe Smith and his daughter Julie Smith, that's not an arm's length bona fide lease that we would say. We would take that to court and we would file the motion for writ, and we've won on cases like that. And we show the judge that this is not an arm's length transaction. This is not a bona fide lease. This is just people making up leases, and it's nonsense. And they can't show proof of payment or to a landlord or anything like that. But back to the question is, we give a 30-day notice that meets the requirements of the Florida statute, because if they come and say, well, we're a month-to-month tenant, and if you don't give a 30-day notice, then you might have a problem. We might go to the hearing and then the judge may deny it. Then we have to go give a notice and then come back again after the notice expires. So we like to do it right the first time. So it kind of is a twofold reason we do that. One is to make sure we're compliant with Florida law. The second thing is to see if they cough up any bona fide lease under federal law that we would have to honor. Now, it's good news, bad news. If you're a flipper, it's not so good. If they come up with a bona fide lease that has 9 more months on it, I guess the glass being half full is that, well, you have the right to demand rent at that point, which I guess gets to the next topic, which is, what if you, and are you ready to touch on this, Marshall? Would be essentially, if you have a tenant in the property, they have a bona fide lease and or any type of tenant anywhere, what's the eviction process at this point? So
I think while we're on it, we might as well elaborate on it, because these are real life situations, guys, that you're going to run into. So unless anybody objects to it, I mean, we have 2 hours total. We're 30 minutes in, so why not?
Okay, so I give about a 45-minute to an hour webinar on this, so I don't want to take too much time. So I'm going to try to make this a little bit concise, but whatever scenario that you run into, and those of you who may be on the call, it may not just be an auction property. It could be another type of property that you have. You purchased a rental, you have a duplex, you have a triplex, whatever it is, traditional sale, and you have tenants in it. Or it could be through an auction that you have a tenant that has a lease and or a month-to-month tenancy in the property. So let me unpack a couple things here before we move forward. What is a month-to-month tenancy? A month-to-month tenancy is where either you had a 12-month lease and the lease has since expired, and then the tenant continues paying their rent after the 12-month lease expires. So you create a month-to-month tenancy upon the acceptance of that 13th month of rent. Another type of month-to-month tenancy is, Joe Smith is fixing up his property, it's a rental, His tenant just moved out, and someone drives by, and there's a lot of rentals in the area, and they say, hey, I'm in between properties. I'm looking for a property in the area. Is this for rent? He says, yeah. And how much? It's $1,200. And he says, okay, what do you need? He said, I'll take first, last, and security. He's like, well, I got $3,600 right here. First, last, security. They exchange money. He hands them the keys. The property's ready. They've just created a month-to-month tenancy. There's no lease. Okay. So there's other types of things such as a week-to-week tenancy in Florida, for example. That's less common. There's a year-to-year tenancy or biannual lease. There's all different types, but generally the month-to-month tenancy is the most common outside of a 12-month lease. Okay. So how do you terminate a tenancy if you have a month-to-month tenant traditionally? Well, you would give a 15-day notice. If you're outside of Miami or Miami Beach where they require 30-day notice, it's a 15-day notice. So if today is August, I think we're at what, August 10th or 11th? What is today's date? I think it's the 10th. If you were to if rent was due on the first of the month and you're to give a 15-day notice today on August 10th, when should that notice expire if rent is due on the first of the month? Most people would say August 25th. Well, that's not correct because it's not, you're on the 10th and then you give a 15-day notice and it's 15 calendar days. No, it's that you must give at least 15 days before the start of the next monthly rental period. So meaning if you serve a 15-day notice today on August 10th, you must give them till August 31st to vacate, okay? So then after August 31st passes, if they're still in the property, we can begin an eviction on September 1st. A traditional county court eviction, if they have a bona fide, or I'm sorry, if they're if you're dealing with a traditional property. If you're dealing with a foreclosure property, the only bona fide tenancy essentially is a lease. So if they have a lease, you can demand money, non-payment of rent. So how do you demand money in Florida? Well, you traditionally use a 3-day notice, okay? It's a 3-day notice, and you serve the 3-day notice. It's 3 business days. You don't count weekends or holidays. And so today is Monday, if you were to serve a 3-day notice, that would expire on Thursday. So day 1 is Tuesday, day 2 is Wednesday, day 3 is Thursday. We could begin an eviction on the Friday for that scenario. There's some new things that are happening right now under the eviction moratoriums, the federal moratorium, the CARES Act, as well as the governor's moratorium. I'll briefly talk about those. These deal, let's talk very briefly about the CARES Act. The CARES Act is for traditional tenancies where your property either has a federally backed mortgage or there's a tenant that is getting federal subsidies for their rents. Most common subsidy is Section 8. If it's one of those 2 categories, or there's a multifamily category, we're not going to talk about that with if they're getting federal mortgage forbearance. That's not very common, but then you fall under the CARES Act. And if it was for rent that was due essentially prior to the expiration of the CARES Act, which was July 26th, then you must serve a 30-day notice on these tenants for that rent. 30-day notice, which you can use the same 3-day notice form, but provide 30 calendar days. Once that notice expires, we can begin the eviction process with the traditional county court eviction process, which I'll talk to you about in a minute. The other type is if you don't fall under the CARES Act because you either don't have a federally backed mortgage or you don't have a tenant getting a federal subsidy like Section 8, then you would serve that traditional 3-day notice, and then we can begin the eviction process thereafter. What is the current governor's moratorium that was just extended that you heard about? Well, what that is the governor actually did extend the moratorium through September 1st, but he made a much more narrow extension for the moratorium. What he said is that all other types of evictions, termination month-to-month tenancy, holdover tenants when a 12-month lease expires and you file the eviction, as well as 7-day notice to cure, so lease violations, all of those can proceed forward at eviction court. Right now, we can move those forward and you can get a writ of possession. So you can get the sheriff to serve that 24-hour notice at the end of the case and you can remove them from the property. So that's great, that's easy. He's also said, essentially in that order, is that you can serve a 3-day notice for non-payment of rent for residential properties, and you can file evictions on them, and you can get a final judgment and a writ of possession unless the tenant raises a COVID hardship. So there's a definition of COVID hardship. I don't have it right in front of me, but essentially the tenant should have to prove that they have lost a job, that they've lost income, and that they've received some type of monetary hardship from the COVID-19 emergency order and the economic situation that's out here.
Sure.
So essentially, yep, go ahead.
One thing on that. That's complete bullshit. And I'm just going to call it out. Everyone has been adversely affected. Unless you're Amazon or a Whole Foods or an Amazon company.
Or a loan officer and a mortgage broker, then yeah, pretty much.
Everyone has been adversely affected. So that's just the scapegoat for an excuse to not get evicted. Can we agree on that?
To an extent, yes, but what I do, so listen, I'm a real estate attorney, but a very significant part of our business is evictions and landlord tenant. So I am adversely affected by this. So I should be the first one that hated the governor's moratorium extension. But, so yes, do I wish that he just didn't extend the moratorium and that we could, landlords could go get back the properties and, tenants need to do what they need to do. They need to go move in with their parents. They need to find roommates, whatever. I mean, I'm sensitive to tenants' needs. I get it. I understand most Americans are having some type of hardship, like you're saying right now. Do I empathize with people? Absolutely. But I represent landlords, and what I hear is landlords crying all day. And they are having a hard time paying their mortgages. They're having a hard time paying taxes. Their income is reduced. They live on a $50,000 salary, and they can barely pay their mortgage, let alone their They have one investment property, and they can't pay that. So people are hurt out there, and we all know this. We're all landlords ourselves, or we work in this industry. So with that being said, specifically what you're saying though is I do like that the governor listened to the Florida Apartment Association. I work pretty closely with them. They have an APAC, it's a political action committee. The Florida Realtors Association, NARPM, which represents residential property managers. There's at least 3 to 4 different organizations that were having meetings with the governor's staff up until a week before he extended the moratorium. And he listened to them. And what he did is he created this Trojan horse, so to speak. So the Trojan horse is that, yes, the eviction moratorium is extended another 30 days, but he made it very clear that the courts need to start moving these cases forward, because these courts were not moving cases forward for commercial evictions, for terminations of month-to-month tenancy, for lease violations, for holdover tenants, for all these other residential evictions other than non-payment of rent. The courts were frozen in almost every single court and almost every single county in 67 counties in Florida. Courts were not moving cases forward because the governor did this and made it clear that all those types of evictions are carved out. Cases are moving forward. And essentially what this is doing is he's saying in the next 30 days from when he extended this through September 1st, I'm going to allow you landlords to start filing your cases and start moving them forward. And maybe some of the tenants aren't going to defend. Maybe they're not going to reply. And then we can get a default final judgment and a writ of possession. Or maybe they will defend and they'll reply and they'll say that, I don't know, that my husband was sick and I couldn't pay my rent, or we got a divorce, we got separated. Maybe they won't raise a COVID defense. I mean, will most raise some type of COVID defense if they do file an answer? Yeah, probably. They will at least allude to it. But then that gets to one final point, because we're going down this rabbit hole, which is, just to reach the end of the rabbit hole, is if and when we get a contested case and we go to a hearing, I represent my landlords, and what I'm going to tell the judge is, Your Honor, you need to read that order very closely. Essentially, our reading of this order is that the defendant must prove that they have a COVID-19 hardship. It doesn't say allege. It doesn't say allege. It must be that they have a COVID-19 hardship. So show me the bank statements back from February where they were making $5,000 per month, and then show me the bank statement today where they're only making $3,000 per month. If they can show that and they can bring that into court, it's an evidentiary hearing, that's fine. We'll stay the writ of possession, give me the final judgment, and we'll wait for that moratorium to extend. That's going to be our argument in court. Whether every judge is going to buy this, whether some judges will have a lot more sympathy and leniency towards tenants, I don't know. Every judge is a little different. That's going to be our arguments.
So Ron, I got a question for you if you don't mind. And I'm sure you've had situations where you filed these evictions. Let's say you started it in, June, or you started it in May, and they were sitting in the court systems. Are you now able to push those forward?
Yeah, so sort of, mostly, kind of, yeah. So what I mean by that, just to give you a more specific answer.
That was the most broad answer I've ever heard.
I'm an attorney, yes, right. I can never give you a black and white answer. It's always got to be gray. You know how that works, Steve. So with our cases that were filed, whether they be back from February, March, and they got held up, or we filed them since, like you said, in May, June, July, for example, for termination of month-to-month tenancy, for holdovers, for lease violations, we are getting hearings and final judgments and writs of possession for those, generally.
What about for the non-payments?
Well, I'll say we're getting final judgments. We're still having a little problem with some sheriffs, some counties, but mostly, yes, like Palm Beach County, for example, as long as you notate on your final judgment that it's not for non-payment of rent, and that it doesn't, it's not covered by the governor's moratorium or by the Federal CARES Act, we can get that writ of possession, for example. So yes, are Broward and Miami-Dade yet serving writs for residential cases? I don't believe so. I'm almost certain that Miami is not. Broward may be changing here fairly soon, but things are slowly moving. Like today, I personally got an email from a judge because we filed so many evictions. I got an email from a judge in St. Lucie County, and he told me that they just had a conference of all the judges in St. Lucie, Indian River, Martin, and Okeechobee, St. Lucie, Indian River, and Martin. Those four, that's, I think it's the 19th circuit. Anyways, whatever circuit it is up there, they had a meeting, and they now are officially on board with these new orders, and they are having hearings on all types of cases, including non-payment of rent, and they're issuing writs of possession unless a tenant raises a COVID-19 hardship defense, specifically for a residential non-payment case. So,
good.
Yeah. So, but things, listen, Miami's not there yet. Just last week, at Thursday or Friday, Miami decided that they would start issuing summonses. They hadn't issued one single summons for any type of eviction case for the last 6 months now, since March. So,
and why I ask is, I have investors. I don't really do eviction work, but I have investors who, maybe do their own evictions because they own it in their personal name, and they tell me, hey, it's been held up since March. I can't do anything. So maybe I can have them talk to you. If you're able to push some of these forward by doing like a motion for for default final judgment or whatever it is. Exactly.
So the good news is we do so many of these cases that we're on the kind of the tip of the sword. We communicate with judges a lot. We communicate with judicial assistants. So yes, our procedure now is we're filing motions for default final judgment and or to set for hearing. Certain judges are even not setting some for hearing in Broward County. So today, my partner and I, we've decided we're going to figure out reasons and rationale why we should be able to file emergency motions. So whether it's the landlord can't pay their mortgage, their taxes, the tenant's beating up the property, we're going to find reasons to file emergency motions if we have to get these set in front of judges. Because there's certain judges that, the farther south you go, the more tenant friendly you're going to find. Not every single judge, but just in general. So when you get as far as Miami, it is super tenant friendly. The sheriffs don't ever want to be seen on the news removing tenants during a coronavirus
that makes sense.
Moratorium, whatever they feel. Broward's pretty darn bad, almost as bad as Miami. Palm Beach is a bit better. They're moving slowly forward. But as you go north, you get more and more landlord friendly, generally, outside of maybe Orlando.
I could vouch for this, guys. In Port St. Lucie, my partner owns an entire rental community. And the sheriff has been showing up doing the evictions. That being said, there's one key word that they're putting in the evictions, and it's forthwith, right?
They're supposed to have removed that word. So it's funny you brought that up. Removed that word because the Supreme Court of the state of Florida they put out an administrative order, and it said that they should remove forthwith from the sheriff's order. Now, So that's where all the confusion is. The Supreme Court's administrative order is still standing. Bottom line, though, is as of today, after the judge told me this, those writs of possession should issue fine. They should execute. And the way the language that we're putting in the orders and the final judgments is they're going through in St. Lucie, Indian River, Martin, Okeechobee, and for the most part, Palm Beach. We're still not all the way there with the non-payment of rent residential cases, where those things will be making their way through the sheriff's office at some point. So,
okay, so now just to rehash and stay focused on the main core competency of this class is buying properties at auction. And right now, there's a lot of people scared to buy at auction for two reasons. One that I'll just touch upon, which probably neither of you are really that familiar with, and that's the title insurance aspect of things right now. It's really clouding things up. But secondly is, I buy it, it's occupied, and how the hell do I get the person out? Is there if I had to give a general, or you have to give a general time frame that you feel is, that you're comfortable with saying, hey, when you buy today, August 10th at auction, you should rest assured they're going to be out by this date. What date is that from today? How many days?
I could answer that, and then Steve, if you want to, chime in and let me know if you're in agreement or maybe you've got different experiences. But I think the first thing we need to do is unpack this, because there's one other thing I want to touch on here, and I don't know if you want to do you want to touch on tax deed properties yet in the auction, Marshall, or
if we have time at the very end, just put a note to circle back to tax deeds.
Okay, so now we're just talking about foreclosure auctions. So let's talk about the eviction part of this. Unless if the tenant produces a bona fide lease, which I can tell you is pretty rare, and do you agree with this, Steve? I don't know, if I had to throw a number out there, maybe of the motions for writ of possession we've done, maybe we see that in about 1 in 5 or less. 10-20% of cases do we see a truly bona fide lease with a regular market rate rent that they could stand on?
I mean, it's very, very rare, and a lot of times we're able to destroy a lot of those leases because they're not an arm's length transaction, or they know these people, or it's a relative. So it's very rare with natural bona fide thing.
So rare, so good. So we're in agreement. Yeah. So let's even say it's I don't know, 10, 15% of cases will have a bona fide lease. Again, that the worst case scenario, if you're dealing with that, the worst case is that, let's say there's 7 months in the lease. We'll just collect rent for 7 months. And you know what? If they don't pay the rent, we'll see them in eviction court. I'll have you give the 3-day notice. We'll file it. We'll get them in front of a judge. And by the time we get it in front of a judge, even if they raised a COVID-19 defense, most likely we're going to have this eviction moratorium lifted here in the coming 30, 60 days by the time we get to a hearing anyways. So,
and I want to say this, guys, to offer just some reassurance for the investors that just don't know any better. You haven't been through this yet. Most of the time, I'm going to say 50% of the time, when you post a 3-day notice, you get paid or they leave. Now, let's move to the other 50%. I'm going to say with 90% certainty, when you post the actual notice that they're going to be thrown out, when the sheriff posts their notice, 90% vacate by then. So when I say I've only had to evict one person, I've gotten to the top of the 9th inning a few times. But by the time we got to the bottom of the 9th, they were gone. So just keep that in mind, that you need to have the ammunition, which is this writ and the 3-day notice and all the procedures that they're telling you. But you'll probably never or seldom, depending on the volume you do, follow through with the actual eviction in its entirety.
It's the carrot and the stick. You were talking about the carrot with the notice, like that you sign the friendly notice. Hi, I'm Marshall, the cool investor. Maybe we can work out a cash for keys, or give you a couple weeks or a month. Let me work on your property. That's the carrot. But if they don't want to play, they don't want to play nice, they don't want to work something out, then you have to stick. And Steve and I are the stick. So, and the stick will get you in traditional times. If they don't have a lease, we serve a 30-day notice to either show that they have a lease, bona fide lease, and or to vacate. After those 30 days, we file the motion for writ. Generally, we would get a hearing within 2 weeks, I'd say, so the 30 days, then 2 more weeks, then the judge grants the writ of possession, and within about a week, you should have the 24-hour notice and be meeting the sheriff at the door. So you're looking at about 7 weeks, give or take, in my estimation, using the 30-day notice, and then about 3 weeks from start to finish with the court process for the motion for writ of possession in a foreclosure court. What do you think, Steve?
I agree. I agree.
Okay. And so there's that. Then let's just talk about, for, let's say there was a bona fide lease. So let's say we're just talking about non-auction properties that you have a lease or a tenant in there, and we have to file an eviction. Traditionally, for an uncontested eviction, you're in Palm Beach County, for example, or Broward County, you're talking about 3 weeks or so to get a final judgment, and then a week for the sheriff in Palm Beach, 2 weeks in Broward. So you're talking about, let's just call it about 4 weeks for an uncontested eviction. For a contested eviction, depends if a judge orders a hearing or in mediation or what they order, but I'd say add another 2 to 3 weeks on top. So you're looking at about 4 to 6 to 7 weeks. Traditionally, right now, for the next few months, we've got craziness going on here, with the amount of evictions going on, the slowdown in the procedures, all of this stuff. So don't count on those timeframes right now. But when things get back to normal here, let's say I would think by early next year, first quarter next year, I think we'll be back to the kind of 4 to 7 week kind of time frame for traditional evictions.
And I'm placing bets, guys, in the chat room section here. And we'll look back in January and see who's right or wrong. I said by January 15th, we'll be back to normal evictions the way that they were. I have no clue. I'm just throwing out a random number. It's like betting on the stock market where it's going to be in 2022. But it's and giggles, guys. Feel free to post your prognostications here.
Yes, absolutely.
So do you guys have any questions? The investors?
I'm going to hold on, let me open this up to unmute first. Alex, I'm unmuting you.
I'm sure me and Drew can probably talk all day and tell you
I know
about the law, but if you guys, have things that have happened in your investments and you guys, want to know how to handle them, you got some good resources there that pay a lot of money per hour.
Yeah. Why don't we talk about some of the worst case scenarios that we've seen so we could set expectations appropriately?
I'll give you one not so great, couple that can happen, and I think Steve sort of alluded to it. One would be an appeal. So you put your money down, you put your $300,000, you paid it to the clerk, and then the certificate of sales issued, but the certificate of title is not yet issued, and they go and they appeal. They head straight up to the appellate court, and those appeals can go on for months, years. They can be problematic, and then sometimes what you have to do is you have to unwind the sale. Steve, I don't know if you've done that. I haven't done that in a little while. I think Corey at our law firm has done a few of those. You filed a motion to vacate the sale and get your money back. And sometimes you have to do that. So it's not like your money has to be tied up forever, but that could be problematic. You thought you won a home run. You think you got 50,000 in equity in the property without even touching it, because no one else bid on it, but maybe they didn't bid on it because they knew something you didn't. Like there was a another thing you can see on the docket too is sometimes you've got very, very litigious defendants. So you'll see that. Like if they filed a bankruptcy twice and the foreclosure's been going on for 5 years, and they filed a bankruptcy twice during that period of time, for example, although really not supposed to be filing it, but once every 7 years, I think, but people will do it for all kinds of reasons. And then they already filed some types of appeals, and even during the foreclosure case. Well, guess what? Do you think they're going to roll over when you purchase the property and the certificate of sale happens? No, because they're probably paying. The other thing is, have they hired Tickton Law or ICE Legal? Those guys get paid, $1,000 a month to keep these people in their property. So if they're paying $1,000 a month, I know a guy.
I'm so happy we have that on the record.
No, but I agree with you, Ron. If they're, it makes more sense to people to pay $1,000 instead of a $5,000 mortgage or a $4,000 rental, and pay the lawyers to fight you as an investor and stay in there for another 6-8 months. Let's file the appeal. Let's file a bankruptcy. I hate my worst thing is when someone files a bankruptcy that is completely unfounded, And everyone knows it is, including the judges, but I still have to go into bankruptcy court and I have to get a motion for relief from stay or a determination that the stay doesn't apply. So I can go back to the state court and tell the judge that everyone's, just playing games.
So I think the investors, guys, the main point they're making is if you think you just win and nobody objects and you're just going to get title and it's smooth sailing, you're wrong and you're going to be terribly disappointed and this is not the business for you. But if you can stomach the fact that 1 out of 10 are going to be nightmares, 8 out of 10 are going to be relatively smooth as long as you use the tactics I've taught you, and then 1 out of 10 are going to be like extreme, right? There's difficult and there's extreme. Steve Sorrell and I right now are dealing with one that's extreme. I'm talking like if I step on the patio of the condo, he claims that he owns the patio and the pool and he'll shoot me. It's beyond extreme. It's psychotic.
Yeah.
So you guys, I don't know who's paying cash and I don't know who's financing these things with hard money loans, but you need to put all that into your, into your projections when you're calculating what you're going to make on something. Well, if you have to hold it for 12 months while you litigate, if you're paying 12% interest or 10% interest or whatever the rates are, that can eat away at your profits. That could push you into bankruptcy. And I mean, we had one for Dominic, that 7 months with a scam artist who got the house deeded to them right before the auction, rented it out, and then fought us in court for 7 months claiming that they had the right to rent the house.
It was ridiculous.
It was ridiculous. And finally they got indicted. They're in prison. They were doing this. It was called the Grave Robbers Group. It was like a organized crime group of people that were going around to people and getting their houses deeded and renting them.
Well, I remember, Jerome probably remembers this. He's probably involved with some of the evictions following this. But during the great crash of 2008, there was a whole scheme where people would actually, abandon their homes, and then like 1 or 2 enterprising people, at least from when I met them, it was a Haitian gentleman who did this. He went and collected about 50 to 60 homes that weren't his, that were just kind of abandoned, took them over illegally and rented them out, and had a whole ring where he was making thousands upon $1,000s, every month. And he ended up going to jail for fraud and everything else. But I mean, he would fight the evictions, he would fight the foreclosures, he would do whatever he could to hang on to properties that he didn't even own, but he was just using for rentals, which I thought was crazy.
Yeah.
It's brilliant, but it's disgusting.
Yeah.
We had another Haitian client of ours that maybe completely coincidental, but they might have been dabbling in equity skimming. We had to fire them at some point when we kind of realized this, where they'd go to a borrower that was in foreclosure, they'd get the property deeded over to them, then they would collect rent and pay an attorney to keep them out of foreclosure, but they weren't really doing anything. They were just kind of collecting money and biding time, and then they would try to purchase the property later, but then they would actually evict the people if they stopped paying rent. But it was their home. It was a whole crazy mess that was going on. But yes, there were a lot of scammers out there. Yeah. A lot of people. Listen, there's all different types of scams too. I mean, I was a part of. We had a client that owned thousands of properties in Florida. This is not dealing with foreclosure per se, but it was sad but interesting. Where there was a ring of criminals. They would know where they were listing these properties. I don't know where they put them on. I don't know if it was like Craigslist or something, but they would also drive around. I think actually what they did more sophisticated, they knew the name of the entity that owned it. So they typed the name of the entity and they found the 60 properties, let's say in Broward County that they owned, or the 160. And then they would go around and they would see which ones were empty that they had renovated and they were putting for rent. They would go take the for rent sign down. They would put it on Craigslist. The renter would come, they would put it for way below market rate. So a property that should be $2,000, they were asking $1,400, but in cash. First, last, and security in cash for $1,400. They moved the people in. And then a couple of days later, the company would see that these people had been moved in. So sadly, we had to do what we'll talk about in a few minutes or down the road, the tax deed sales. We would have to file an unlawful detainer against these poor folks. I mean, the company tried to do the right thing and said, hey, we'll work something out with you but you need to get out in a couple weeks. You're not our tenant. We don't have a signed lease with you. You know, this lease that you're showing me is fake. We believe that you paid these people money, but this was a fraud ring that did this to several hundred properties of theirs over a period of like a year. The FBI went in and busted them, and these people are doing decades in jail because they came out of close to $1 million.
It's ironic, Jaron, that you're bringing this up today, because next week's interview is with a federal prosecutor, Mr. Schwartz, and that's the exact case we're talking about on our Zoom meeting. It's still happening, and we actually had properties I own that were vacant. I have a townhouse that I built, or a multifamily in Hallandale. The other day, someone calls up my office and says, "Hey, I just gave this guy Mike $800 deposit, and now he won't answer my phone calls or anything." I'm like, "Forward me the email. Let me see what you're talking about." So there's some guy saying his name is one of my agents, and he's not. I have a real agent. Let's say Michael Johnson. He creates an email, michael.johnson@gmail.com. He puts a sign in the ground, and he puts my house up for $900 when it should be $1,900. He takes a wire deposit, and now he goes missing in action.
Yeah, sure.
He did this to like 10 people, and it's a ring of criminals.
And most of the time, they're pretty smart. They actually got the name of the company. They incorporated, so let's say the company was whatever, RDH, or the number 1 LLC that was on the deed. They created RDH ONE, LLC, RDH1. So even if the tenant was fairly savvy and they said who's the owner of the property, and they looked on the property appraiser, they would see, because what they would do is they would make out the lease and the money orders to RDH1. And so they had a bank account, and they would be able to go and put this money in. It was crazy. It was like a whole
This is a very common theme with embezzlement. And I see this over and over and guys, so you understand, with Florida, and I don't know if it's the same with other states, I could literally, if it's Jaron Kelly Law LLC, I can go on Sunbiz right now and open up Jaron Kelly Laws LLC. Just add an S, or instead of double L and Kelly, I can make it a single L, or double I, so it looks like 2 capital I's look like 2 L's. There's so many schemes to get around the system. And these criminals I don't even want to say they're smart. They actually use some of the most simple tactics that we all oversee. But you need to be cognizant of this. This was not even to be brought up in this meeting, but guys, you're all subject to this, and you have to be aware of it in every aspect of when you're going to buy properties and you're going to see people trying to defraud you.
That's a good teaser for next week. So now everyone has to come back.
Exactly.
Figure out, and hear the speaker.
Yeah, that's right. It's good content. Do we want to talk about quiet title at all and title issues, or?
Yes. Why don't we first explain the word quiet title? To me sounds like the title was being real noisy and you quieted it down. So why don't we explain? Yeah, shut up, title. Why don't we explain to the guys that have, including myself, that really don't understand the complexity of it? How do you define what quiet title action is?
Steve, you want to do that, or me, or?
You go ahead, please.
Okay. Well, I think we need to back up just for a minute and talk about, you purchase a property through foreclosure. It's fine, but at a certain point, you're going to need to sell the property. Okay. So when you are looking to sell the property in a traditional manner, the buyer of the property is going to want to get a title policy. So you're going to get a title commitment. Really, what you probably should be doing at some point, if you haven't already somehow done some type of at least basic searches prior to purchasing the property, which I'll let Marshall deal with on what he does, and I'm not going to get into that. But once you've decided that you are purchasing the property because you think that generally it doesn't have federal tax liens on it, or 200,000 in fines from what Steve before said was, some type of code violation because your lawn wasn't kept for 2 years, whatever the issues are, which, by the way, technically that just a code violation wouldn't actually be a title issue unless it rose to a lien. If it was an actual municipal lien, then yes, then it's a title issue. But whatever it is, the title company, when you're deciding to sell, or even just you want to run a title commitment on your own right after purchasing the property, which you probably should do because sometimes it takes a while to clean up these title issues, our recommendation is come to an attorney, come to Steve, come to myself, come to a real estate attorney that can run a title commitment on the property and find out what those issues are and what you might need to do to clear it. Because perhaps, you know, the property was properly foreclosed on, perhaps it wasn't. Maybe you need Steve to go back and re-foreclose, or maybe you do need a quiet title. I can tell you that our title commitments and most title commitments, and we'll get to this later, but the tax deed auction, every tax deed auction property that gets sent our way and we run a title commitment on it, our underwriters require a quiet title on that. There may be another option, which Marshall can talk about or Steve can talk about, but generally title underwriters want a quiet title lawsuit. So what is a quiet title? Well, it's when there's a cloud on title that needs to be cured. And how do you do that? Well, you can only cure it, well, it depends on what the cloud is. So for example, let's say there was a deed 3 deeds ago that maybe there was a married person and the wife, her name wasn't on the deed, but she should have signed the deed, even though her name wasn't on it, but she had some marital interest. So you might have to go back and find that woman's name and figure out where she lives and go incentivize her to pay her $200 to go sign away her interest on the deed, so that, and we can file a corrected deed. That might be all that you need on a foreclosure property, maybe something as simple as that. But let's say this woman's deceased, or let's say that, you know, she lives in Zimbabwe now and no one knows where she is. They can't get a hold of her. You just can't find her in public records. Well, maybe you need to file a quiet title and name her as a defendant. Maybe you need to name other parties as defendants who might have some possible interest in the property that were not foreclosed out in that foreclosure. They were not named as defendants. So it's kind of like a new suit that's similar to a foreclosure, but the purpose of the foreclosure is twofold, which is essentially to quiet the title of certain defendants, but also to gain possession of the property for the rightful plaintiff, so that they can get possession back and or to be essentially to be sold to the third party, whoever that third party is. Maybe it's the plaintiff, like the bank. Generally, oftentimes the bank will purchase these properties, or a third party, whatever it is. It's to sell the property, to get the money at auction, disperse it properly, and have their interest quieted. A quiet title is the only reason to do a quiet title is not to sell a property generally. It's not to, you know, to get money at auction or to whatever, exchange monies. It is simply to deliver true and clean title to the plaintiff in a quiet title lawsuit. So
yeah, I just want to add in real fast, just, you know, and a lot of times people come to me after a quiet title and they say, well, you know, my title's quieted, you know, give me my title commitment, or give me, you know, the title policy. You get a final judgment quieting title, but you still need to insure the property, you know, through a traditional title agent. So it's, you know, like Jeron's trying to say, and I guess I'll try and reinforce, is that what we're doing with the quiet title is a requirement done by the underwriter in order for us then to go ahead and sell the property with a warranty deed and insure the title. So the quiet title itself, the judgment's not going to really get you much. I mean, it's fun, it's nice, you have it, but, you know, you still need to go through the process of selling it with a warranty deed and getting a title insurance policy.
correct, which is why I said one of the first things you probably want to do is get that title commitment. So let's say it's from Fidelity. There's multiple underwriters out there. There's Fidelity, there's Old Republic, there's Westcor, there's Chicago, there's a bunch of different ones, Stewart Title. But let's say Fidelity is one of the big ones, or First American. But let's say you go to Fidelity and Fidelity says, here are your requirements. You must file a quiet title. And let's say there's 2 other requirements, major requirements that you need to do. Well, make sure you know who you need to foreclose, whose interests you need to foreclose out, because Fidelity is going to give you that roadmap to tell you, well, need to name these parties as defendants, essentially, because right now will be exceptions on the policy. So in order to clear those requirements, you must do a quiet title and essentially to name these parties. So that's the roadmap that you need and that we need to properly file this quiet title lawsuit and get that proper judgment that quiets out those different parties from the title. So Steve, do you have anything else to add on that?
For the quiet titles, no, I think you covered. I mean, I think that's essentially what a quiet title is.
Can we apprise the investors here tonight, roughly, what can they expect to spend on a quiet title action, start to finish?
I'll let Duran go first because then I can underbid.
I was getting I've been talking too long.
Oh, no.
I don't have any more breath. You first, Steve.
So I mean, I don't have a big firm like Duran. I mean, he has a lot of attorneys and he has a lot of people that can do the work. But for me, I do most of my work. I only have a few paralegals, and I have another attorney in my office. So in order for it to be worth my time, and again, I take some of the dirtiest, nastiest titles and I clean them out. We do a $2,000 flat fee plus whatever the cost of the filing and the service are. So for a quiet title, that's how we operate.
I think that's very reasonable. Yes, that's a good market rate. So, yep, agreed.
I will say this: Steve is not the cheapest. My partner Eric goes with the cheapest. I go with the best. That if I send him a file, I don't have to check up and call him every week and see what's happening. I know 3-4 months later, whatever it is, I'm going to hear back and he's going to say, okay, you're good to go. It's done.
Hey, Marshall, just so you know, Eric's attorney and his new attorney doing quiet titles called me to ask me questions on how to do a quiet title.
Okay, guys, and for the class and for Aton, especially, like we're always talking about, I give a lot of my referrals of different people, from tile to you name it, to painters. None of my people that I work with are the cheapest. Nobody. Now, that being said, they are the best value. And there's a big difference between what you pay and what you get. What is it? Warren Buffett says, price is what you pay, value is what you get. And it holds true in this industry. Yeah. I don't get anything for supporting Steve or Jaron or any of the people that we bring to these meetings. All I can tell you is from experience, I've kissed a lot of frogs to find the right prince in these cases. And these are the best of the best that I've already filtered out for you. So that's my endorsement of you guys.
Thank you. I really, I appreciate that. I'm sure Jaron does it.
Appreciate that.
One of the things I think, I can say this about Jaron and myself is I think we really take pride in what we do, and we really make sure it's done right the first time. I've gotten files from other attorneys where it's come to me and they've done a quiet title, but they've messed it up, and now this person's paying twice again. He's paying me again to go do something that could have been done the first time correctly. So I would I send my evictions to Jaron. I trust him to do it. You want to make sure that the people that you're working with are the specialty people in the area. They know what they're doing, that they're going to have care for your product and for your bottom line, and even if it might cost a little bit more upfront, I think the peace of mind. And I don't think that it costs money. I mean, you can go out, you can probably find someone cheaper, but you can always find someone cheaper. What you really want to do is make sure that things are done right and that you don't have to worry about it later on when you're going to sell the property and find out, oh, now I can't close. I have this additional issue.
Yeah. No, I think your costs are very reasonable, Steve, and yeah, like you said, even if there's someone out there that they can get their little peepees kicked into the dirt by Eric, doesn't mean they're going to get better results. So
And now, what about for evictions and writs? What's the rough estimate on what people should expect to pay?
I don't do evictions, so I'll let Jaron take that. I refer to him.
Yeah, so on evictions, we charge $195, which is our attorney fee, plus the filing fee is $185, plus the summons is $10 for each tenant, plus the process server charge is $40. So essentially, you're looking at $435 for a one-tenant eviction. That's for an uncontested eviction or a contested eviction that doesn't require a hearing, for example, or like like if we have to negotiate a stipulation agreement with another attorney, that there might be a little extra fee for that. And that doesn't include the $90 for the sheriff. So you're looking at anywhere from about $435, which I would say is at least half the cases are $435. Maybe you add another $90 for the sheriff in there, so give or take around $500. About half the cases, maybe a little more, and then some have hearings. So maybe you're looking somewhere between $500 and upwards of worst case scenario. You're looking at maybe $1,200, $1,300 worst. That's like, you know, you're going to contest a case and hearing, mediations, stuff going on. It's very contentious. And then for what we charge for the motions for writ of possession, I believe it's about $600, give or take. That includes the notice we send out via certified mail, and that also includes the sheriff, the $90 for the sheriff.
So guys, be mindful. You know, when you have a $10,000 a month rent, it's one thing to follow through with an eviction, or even there's got to be a certain threshold where it makes sense. But if you're talking about a $700 per month rent, and it's going to cost you $700 or $1,200 to get them out, you need to make a business decision very often. Like right now, I had 3 tenants this month who very nicely came to me and said, listen, I don't want to burn you, but I can't afford my rent. This is residential. What can you do? And you know what I said? Thank you for being honest. I gave them back their entire security if it was, you know, if the property wasn't destroyed, which thank God none of them were. I said, let me keep your last month for this month and move out on a handshake, and I'm not coming after you. I sent an email, no agreement, no signed affidavits. Technically, I could go after them for what the lease says, which is either 2 months damages or the entire term of the lease, which most of them were like 3 to 5 months into a 12-month lease. So the point being, you have to make business decisions with all these, whether it's something that you've purchased at auction or it's something that you bought as an investment and you have tenants in place. I knew that the cost to get them out through the legal system, not only the time, but the financial cost, would exceed just giving them back security and moving on to someone else the next week. So, you know, again,
don't be greedy.
Not to work against Jaron and Steve and what they do, but if you could settle these things, Steve is the first one to always say to me, dude, if you could settle this on your own, like, please go do it. And you know what? 1 out of 5, I probably cancel on him and say, hey, I worked it out. It's okay. Yeah. These guys, they'll work with you.
100%.
100%. Agreed.
So, all right.
Don't be greedy. Yep, absolutely.
Did we pretty much cover everything that we had on the list of topics?
I think so.
I think the only other thing maybe was the tax deed sale and unlawful detainers for me, but other than that, yes.
Why don't we spend 10 minutes on the tax deed sale till 5:30, then we'll open up for questions and answers, and we'll wrap it up. Or I say 5:30, sorry, it's 7:30 at home, right?
It's 7:20 right now, yes, it'll be 7:30.
Yeah. Okay.
So I think Steve covered some of that with regards to the tax certificates and then the auction, but I guess what happens after the auction? So you prevail on the bid, and then you're going to get your tax deed. Your tax deed will get issued. And then what? What do you do? Well, there's 2 things, one from a title perspective and then one from a possessory perspective. Let's talk about the possession portion of it first. Well, I would say, well, first thing you probably do, and Marshall, I don't know if you purchase tax deed properties or what you do, but I would assume it would be very similar. 3 ever. So, but I'm assuming it would be the same procedure that you would do with your foreclosure properties. You go put your notice out there. You say, I'm Marshall. I'm a nice guy. Talk to me. Give me a call. Whatever you need to do to see who's in there. And if you can determine who's in there, that's wonderful. That's really good. So you really want to determine if it's one of 2 different parties. One is going to be the prior owner is going to be in there, which I would say, especially with tax deed sales, probably 95% of the time, even more than foreclosure properties. Foreclosure, at least from my experience, there's I don't know, maybe 20+% of the time, there's tenants in the property, maybe 30% of the time. Not all of them do they have leases. So I'm not saying we talked about that, maybe 10% have leases. But with tax deed sales, from my experience, because we do a decent amount of these unlawful detainers for them, I'd say 90, 95% of the time, the former owners are in there. I'm not going to get into the psychology of the reasons why people don't pay their taxes and they live in their property. But so with that being said, what do you do? Well, what we do is what's called an unlawful detainer, and that's the evictions are Chapter 83 of Florida statute. Unlawful detainers, Chapter 82 of Florida statute. What are unlawful detainers for? Well, they are for essentially squatters or people who are not tenants that are in possession of the property, who do not own the property or have the right to be in the property. So it's people who need to go, bottom line.
Is this also termed as ejectment actions? Is this kind of the same thing? Different than ejectment.
So this is, so the blessing with the unlawful detainer, where it's different than the ejectment, is unlawful detainer is county court, and it's about the same time frame as an eviction, whereas an ejectment is circuit court, and that could be, as you know, any circuit court action could be a year or more, depending if it's contested and how heavily contested. So we've been 99.9% successful with unlawful detainers. We've done hundreds of them over the years. So we give there's no actual notice period technically you're supposed to give, but we give a 1-week notice that we draft up and we serve. Every court has deemed that to be reasonable, just to put it on the record that you are asking them to leave outside of a verbal request. So it's a written request. You must vacate the property in a week. Assuming they don't vacate the property, which they almost never do, then we go ahead and we file the eviction in the county court. It's not an eviction, Chapter 83. We file the unlawful detainer, which is like an eviction in the county court. If it's uncontested, we can get a final judgment in as little as 3 weeks after filing. If it is contested, it will go to a hearing or a trial, it's called. And at the trial, 99% of the time, unless they can prove that they're a tenant or they have some valid reason, like they have an ownership interest in the property, perhaps, maybe. Those are the only real reasons we've ever had issues with. We would get a final judgment, and then we can get the writ of possession of the sheriff out there. So the total time frame for that, when you have the 1-week notice plus, depending if it's uncontested, I'd say you're talking maybe 5 weeks to 7, 8 weeks, depending on if it's contested or uncontested, depending on the county and the judge. So that's what we do for tax deed properties. And then with regards to the title on tax deed properties, like I kind of alluded to or mentioned before, every time that we pull a title commitment on a property, so an investor comes to us, says, hey, Jaron, we just got this property. I bought it at the tax deed sale. Here's my tax deed. We go ahead, we run the title commitment. Every single time our underwriter, we have 3 different underwriters. They always ask for a quiet title on the property. So therefore, we get the title commitment, we figure out that roadmap of who we need to name in the quiet title, and we proceed forward to the quiet title. There is an exception to this, which I don't know if you know much about, Steve, but there's a company out there, it's another law firm, they have a company where you can, some cases you can avoid a quiet title lawsuit. I'm not trying to cannibalize our business, but you could pay a couple $1,000s, or I think it depends on the price of the property, and they are able to somehow insure this. I forget the name of the company that it's out there, but you can look that up if you ever get in a situation and you need to try to avoid doing a quiet title suit. It can be a little faster maybe than a quiet title. The pricing may be somewhere in between or somewhere around the same price, but that's an option. So,
and I would bet you guys that they're probably based out of Miami, because anything that seems a little obscure, shady, not standard, usually it originates from a Miami firm.
That could very well be, and I'm not promoting it. I'm not saying it's the right thing to do. We don't do that. We do what our underwriters tell us to make sure you're getting clean title. I believe Steve does the same thing.
Right.
And you can never go wrong, even if it takes an extra month or two to do it the right way in court. Get your quiet title, get your clean title policy, and move on.
Yep.
And by the way, so you file the unlawful detainer right away. Then you get your property back, and let's say hypothetically 4 or 5 weeks, 6 weeks, 7 weeks. Then in the meantime, we could already start, and Steve could start a quiet title lawsuit right away. You don't need to have possession of your property. You get that filed, and then let's say by the time you're done getting possession of your property from an unlawful detainer, you're going to be halfway through that quiet title lawsuit anyways, and then we can go ahead and you get possession, and then go start fixing your property up. It may take you 90 days to fix your property up, and then on top of the 6 weeks it takes for us to get possession, by then the quiet title suit should be done or close to being done. So
now, one thing I noticed, I've bought 3 or maybe 4 tax deed sales in my life, and Steve Sorrell, who handled my quiet titles afterwards, always said, hey, you sure you want to do this? If you're going to keep it as a rental, there's a certain time period that, I don't know if it's 3 or 4 years, that if you don't do anything, it clears itself. Is that the case?
Yeah, I mean, from what I understand, and maybe I'm incorrect, but I believe that the title essentially cleans itself after a 4-year time period. So I've had a couple of discussions with, I write primarily with the Attorney's Title Fund under Old Republic. And, you know, essentially, unless it's something that's crazy that can't be explained or was a complete mistake, most of the cloud on title can be corrected itself after a 4-year statutory period. However, most investors don't really hold on to these properties. They want to sell them before 4 years, which is why we do quiet titles.
Jaron, are you familiar with that?
yes, there is a statutory period, and I believe Steve is correct. It's either 4 or 5 years, but I trust Steve, so it probably is 4.
Okay, so just to keep that so you guys understand, you're buying at the tax deed auction. You're not flipping. You're keeping it as a rental like I've done with the few that I purchased there. There's no need to spend $3,000 or $4,000 quieting the title if you're going to keep it as a rental, unless you're fearful that you may need to sell it for some unknown reason, or, I mean, in the event, God forbid, you drop dead and like your wife inherits or your husband inherits the property and they want to sell it. That's the reason I did it. Something happens to me and my wife needs to liquidate some assets. She's not going to know what the hell to do. So let me have everything cleared up now.
Yeah.
You know, because
I mean, the other thing to worry about, Marshall, is, you know, people make mistakes. Now, I'm not saying people, but let's say a second mortgage who, you know, wasn't noticed properly by the tax deed clerk, doesn't know that the tax deed has happened, and they file the foreclosure. You start filing the foreclosure, and then no one knows what's going on. They're serving the old owners, they're not serving the new owners. I'm just thinking like what is the worst case scenario that can happen? A third party purchaser buys it, they think they have title, but you really have title based on the tax deed, where the second mortgage should have been extinguished or was extinguished by a tax deed sale, but no quiet title happened. So, you know, I do stand by the 4-year statute of limitations thing. However, you know, beware. I just want to say, you know, there are so many times where a mortgage will foreclose and an association will foreclose on the same property. And then, you know, we're arguing about who has title. Well, obviously the first mortgage has title, first mortgage holder, but, you know, you don't want to be in a situation where you're having to defend your title.
yeah, and we've been there before. Steve and I have been in that predicament. So, all right, we're going to wrap this portion of the meeting up with, and also one pointer I want to throw out there, guys, is this. When you buy at auction, and this should be like your main takeaway from me for tonight, is always get into the property after the auction. And I'm going to give you my tip on how I tell people I need to get in, because very often they're protective of their property. So I just bought Miss Johnson's house at the auction. She got my letter, and she says, I'm not letting you in here. I'm going to live here for 30 days. I'll be out, I promise. I tell her that in order for me to honor my agreement, I need to get photos for my insurance. Even if I don't put insurance on the house, call it a white lie, call it what you want. I always use the insurance as the scapegoat to get in. And I say, if I can't get into the house, I can't get insurance, then I can't let you stay there. 100% of the time so far, it's worked. And it's actually helped me, because I've purchased properties like one I spoke about this morning on the Property Onion I was interviewed by. And I spoke about the case where, thank God, I took a live Facebook video of the property I bought, because the next day the old owner came back and lit the place on fire. And I had insurance on it, and the insurance said, well, you insured it after the damage took place. I said, no, I didn't. They said, well, can you prove it? And I went through my Facebook, and sure enough, there was my Facebook page showing the video of the house fully standing, not damaged at all. And then these people went in there and ransacked it, lit stuff on fire, burnt everything, broke every window, caused me over $100,000 in damage. And I was able to not only prevail with the insurance, but I believe they're going after the prior homeowner in a separate case. the whole basis of this is if I didn't take that Facebook video, if I didn't have pictures, if I didn't access the home, I probably would have been in a really bad place with regards to the insurance settlement. I don't know if it would have been in my favor because it was just the time frame of I bought it at 10 a.m. on the 2nd, and at 12 p.m. on the 3rd, the place is gone. It didn't add up. So document everything, take photos, take videos, go overboard with, I even take videos of my watch. I show the date and time. I did the same thing with my rental car today from the airport. I walked around the car. I said, today's the 10th. It's 7 a.m. Here's the dents. Here's the cracked windshield. You need to always think, as everything you do, is it going to be watched by somebody who's opposing you at a later time? That being said, let's open up the meeting now to Q&A. Anyone have any questions?
Yeah, yeah, Marshall, I have. Yeah, so thank you guys so much for the explanations. And I know that we've done business with both of you, so I can say from personal experience that you know, you each are a pleasure to work with, and so thank you.
Thank you.
So I have a couple questions. I guess the first one is, other than you know, the requirement on the title commitment, why are the underwriters requiring a quiet title for a tax deed? I just sort of taken that as a given. Every time you buy something at tax deed auction, you have to do a quiet title. But what specifically is the reason for that?
I think yeah. I mean, from my point of view, and I'm just, you know, I wasn't told this, and I didn't read it, I'm not taught it, but, you know, if you want my opinion on it, it's that they want to make sure that the interests that they're going to be insuring are clean. So it's almost like an insurance policy for the insurance policy. You know, they want to make sure that, you know, they give us the roadmap, but they don't, they don't know who the unknown heirs are. Let's say, for instance, for a tax deed, you know, someone, you find out someone is dead, and then they, the insurance company will say, well, you need to do a quiet title for the unknown heirs. We don't know who they are, but there may be someone out there that may come back later on and say, I have an interest in this property. No one noticed me, which is a defense against a tax deed sale, that I wasn't noticed, I didn't know. And they want to have insurance that you did everything as the purchaser to hire an attorney to figure out that all the interests have been cleared. So that's how I look at it, and that's what I think is why an insurance carrier would want a quiet title. But maybe Gerard has another opinion, or maybe he knows.
No, I fully agree with you. I would just say, I think one of the things to kind of keep in mind, the difference between a foreclosure property, why not all foreclosure properties require a quiet title from underwriters, is that those foreclosure law firms have already gotten the roadmap from their underwriters. Essentially, like they've pulled their title roadmap, and so they've named all of those defendants already. They've done all the hard work up front, and all of those folks that needed to be quieted out were named as defendants. So they'll name the state of Florida, they'll name the U.S. government for tax liens, they'll name Department of Revenue, they'll name the city of Boca Raton, they always name the associations. So they essentially are quieting out all of these claims in the foreclosure lawsuit. Whereas in a tax deed, essentially that's the whatever it is, the city or whoever is foreclosing on it. But it's not even foreclosing, but whoever's doing the auction, they are not foreclosing out other interests. There is some type of there are some statutory provisions in there, which Steve discussed earlier, such as where some municipal and or state and or federal liens are not included in this, and maybe mortgages are, but it's not all encompassing, and it's not super, super, super clear. So, and then there can also be issues with, for example, deed issues and heirs and deceased folks that you need to quiet out. And those are the hard ones. Those are the ones where you have to publish, for example, in a newspaper, because someone died, grandma who had an interest in the house died, 15 years ago, and there's 5 siblings. So
yeah, and just so you guys know, a publication for a quiet title, unlike a foreclosure, is 4 weeks, where a foreclosure publication is 2 weeks. So just keep that in mind when you're thinking about time frames for a quiet title. If there's a dead person, you're going to add a month. Just add a month to it.
Yes. Yep. Does that help?
Yeah, I mean, it's funny. It almost seems like a quiet or quiet title for a tax deed is like a foreclosure in reverse, where it throws the burden of clearing title and doing all the noticing to the buyer, almost because it's the government. So the government says, "Hey, we'll just give you the property, or we'll sell you the property, but then you clean it up,"
Yeah.
rather than a judicial foreclosure process.
That's it.
And so,
They wash their hands of it. They say, "Give me my money," and I'm washing the hands of it. Now it's your problem.
Yeah.
You clean up all the fleas and ticks.
Yeah, it's kind of, you know, think about it now. It's kind of like a quick claim deed from the government, and then here you go, you got to take care of it.
yeah.
That's interesting.
Yeah. So one other question I have is I'm in the middle, and this is, or not the middle. I'm at the very end. I've been at the very end of a partition suit that's been going on for over a year, and lots of issues, and I don't want to go into that. But the most recent issue was the auction was scheduled for right when coronavirus hit, and then there was the moratorium on foreclosures, and then we filed a motion to and this is in Broward County, to reset the foreclosure date, and the judge still won't hear the motion from April. So are you guys seeing stuff with partition suits that are being affected by the moratorium?
I mean, we've been going, I mean, you know, when it comes to writs of possession and things of that sort, it's been tough, but you know, we've been moving forward pretty steadily. And I think Jerron just told us before with dealing with his evictions, you know, things are starting to open up a little bit. Judges are starting to move cases forward. They don't want things just sitting on their docket. So I've seen an opening up, and I've seen kind of push to get things moving again. But you know.
Yeah. All I could say, I don't know for petition actions specifically, and for foreclosures, we haven't, we haven't been involved in any re-foreclosure actions or specific partition actions that were prepared for a foreclosure in the last few months. So I can't speak eloquently on exactly where it stands today. I can tell you that Broward and Miami are a little slower than most counties. I would just make sure that your attorney is aggressive in, contacting the judicial system and the court at least once a week, because things change. Things are in flux right now. New procedures coming out there. So, just be patient, and it will free up in time. But, in Broward County is always a little more difficult to deal with than Palm Beach, for example.
Yeah.
So, and just thank your lucky stars you're not in Miami, because it's even worse there.
I mean, it almost seems crazy to me that they even stopped the auction because of coronavirus. And why stop it? It's a partition. It has nothing to do with foreclosure. But I guess they lump it together when it's convenient for them.
That's exactly what the issues are. So we've got, for example, in Broward County, they're just right now not really serving writs of possession for any residential cases, where Palm Beach County is serving residential cases as long as it doesn't have to do with non-payment of rent. But you go one county north of Martin, and all residential writs, as long as the judge is authorizing it, are getting executed and served. So that's I'm just giving you an analogy of writs of possession to foreclosures. It's certain counties and clerks and courts are very slow to enact proper procedures under these changing orders that are coming out from the governor and the state.
It's a tough place, guys.
What's that?
I was saying, this is a really, I put myself on both sides of this. From the tenant's perspective, they're out of work not because of anything they did wrong, right? You're a bartender, you work at a hair salon, you didn't do anything wrong, and now you're out of income. From a landlord's perspective, which is predominantly us tonight, it's, well, I took a mortgage, I pay taxes, I pay insurance, and I still have to make repairs. And that's my question for you. I'll get to in a second. Is it fair for the government to impose upon me, private enterprise, that, hang on a second, I can't collect my rents and there's nothing that I can do? It seems unreasonable. I don't know what the right answer is, but I do have a question about it. I have a property. Tenant refuses to pay rent. They say that she's a nurse, even though the fact that she's a nurse, she doesn't want to pay her rent right now because it's coronavirus and the governor said she didn't have to. She calls me yesterday and says, my AC is not working. am I liable to fix her AC on a month-to-month lease? Am I responsible to do anything at this point? If she doesn't have to pay her rent, do I have to maintain the property? And if I don't, what can happen to me?
Yes.
AC is important, right? I mean, the AC is one of those things that's statutorily guaranteed. But Jerron, you're the eviction guy.
Yeah. No, I agree with you, Steve. And it is in the statute, and the landlord has a duty of maintenance. That's in the statute. It's probably in the lease as well. And two wrongs don't make a right, if I just had to put it in layman's terms. So just because they're not paying you rent doesn't mean that you get to go and not maintain the property. So that's the legal answer. So you need to still continue to give reasonable maintenance on the property. Listen, if while they're paying rent, if you would have gone over there to go fix a light, or a fan or something, whereas now you're like, screw you, I'm not going to go fix the fan. I'm okay with that, really. Between you and me, that's kind of off the record here on a webinar. But with regards to air conditioning, don't you want to fix the air conditioning? I mean, meaning, do you want your rental property to be growing mold if it's not cooling below 82 degrees? I don't know. That's where the rubber meets the road. I mean, I could give you the law, but I can also give you, I have 10 units that I run out, and I definitely would always fix the air conditioning. I don't care if they're
The bottom line is the landlord is still bound to maintain the property, even if they're not collecting rent.
Yes, bottom line. That's it.
And if the landlord defaults and says, no, I can't afford to because I'm so stretched to the max right now with my mortgages, my taxes, my insurances, I can't afford to fix or replace your AC because I count on that income from the rent to do this stuff.
Yeah, but you may run into a situation then where her obligation to pay rent is then obviated or lessened because you didn't provide AC. So you don't want to go in front of a judge. I mean, I don't know, but you don't want to go in front of a judge and be the asshole in the situation where the judge is now sympathetic to the tenant because they don't have AC, especially if you have to count too for damages.
It's a hypothetical, but it's like
it's
a really interesting situation.
Yep.
The chicken or the egg.
Well, it's just like maintaining the utilities. If the person's not paying and you're, actively doing an eviction, you still have to keep the utilities on. You can't shut off the water. You can't shut off FP&L if it's in your name.
If it's in your name, correct.
Correct. Exactly. That's self-help, and yes, you don't want to do that. There's a 3-month rent penalty for that if you do that.
Gotcha. Good to know. Are there any other questions regarding tonight's discussion?
So Marshall, I actually had the same situation, and I was nice, and I tried to fix the AC. I'll try. Let me start the video. This is Alex.
I'll check.
So I did have that situation where my tenant, the AC broke, and I actually tried to fix the AC. It was in a condo, and the unit had a 6 to 8 week lead time to get a replacement because it was some special 4-ton unit for this condo. And I actually talked to a lawyer, and her husband was a lawyer in Florida. If you think about it, it covers all the way up to northern Florida. AC is not considered essential. You do not have to provide it according to the lawyers I've spoken with, unlike what Jaron and Stephen said. I did go out of my way. I put in temporary ACs, but she was still arguing with me, and I ended up giving her a 10% reduction per month on the rent for it because of the inconvenience. But from my understanding, it's AC, unlike power and water, AC is not required.
So Alex, you're technically correct. Only heat is covered, not air conditioning, because it's an old statute that dates back to, I don't know when Chapter 83 first started, maybe back in the 1940s, and that was never put in there technically. So you could raise a technicality if you want to get into it in a landlord-tenant hearing. Depending on the judge, maybe you find a very landlord-friendly judge that would say, okay, I'm going to have a strict construction, strict reading of Chapter 83 of Florida statute. But more realistically, most judges are going to say, if you deliver that property with a central air conditioner that was working, and there's nothing in the lease that says that they must maintain that, which I still even think that would be inequitable for a tenant to have to replace a $10,000 central air conditioning. So if you're in agreement with that, which I think 99% of people are, even landlords, there's a duty that you have to maintain how you rented the property out to them in the beginning. You
now,
can't say.
Sorry, go finish what you were saying.
I think it's absolutely unreasonable and inequitable. And listen, I'm a landlord attorney. I only represent 99% of the time I represent landlords. But I will say that almost every judge out there would find it to be unreasonable and inequitable for a landlord to expect a tenant to replace a $10,000 or even a $5,000 air conditioning unit, even if you had it in your lease that said they must do that. Our opinion, legal opinion, is that yes. Can you require them to change air conditioning filters? Yes. Could you maybe stretch it? And if they had a wall AC unit, to replace a wall AC unit on a 1-bedroom apartment, like I have a quadplex and it's all wall AC units, maybe I could get away with that, but not a central AC unit. I don't think you're going to find any judge anywhere that's going to agree with that. So,
Now, Jared, part 2 of my question. One of these investors or myself buys a property at auction. Someone claims, oh, I have a lease in place. I just bought this thing in the morning. He goes, I have a lease and my AC doesn't work. Fix it.
Is it a bona fide lease? So, for example, if the property can rent for $1,600 and they have a $1,500 lease, which I would say is fairly reasonable and within a, give or take.
Let's say it's not a bona fide lease. It's your typical. Okay, I say typical. The few cases I've had where people came to me and said, hey, I have a lease. It was like $200 a month for the next 30 years for a $7,000 a month house, right? So now they try busting my balls and say, oh, the roof's leaking. I'm getting mold poisoning and the AC doesn't work.
No, don't. You do not have to fix it. And you can send them through the motion for writ of possession process like Steve does or I do. And we'll go piggyback off the foreclosure case and we'll get them out. And you do not have a duty to maintain because they're not a tenant at that point. They're not a bona fide tenant. They don't have the rights that tenants do under Chapter 83 of Florida statute.
Guys, that's huge news for you guys, for the investors. If you're ever fearful of when you buy at auction, could you?
That's my opinion. Steve, do you agree?
I agree with that. I agree.
And if these guys agree, I would say with 99% certainty that it's reasonable and a judge would agree as well. Unless you get like this one judge that we won't talk about.
I probably go in front of them all the time. So, yes.
Any other questions or comments or anything? We got 8 minutes to wrap things up. Or we could wrap them up early. No? All right. Well, then we will conclude things with, again, everyone's contact information. So I have Jaron Kelly, Esquire, here in the chat section with his phone number and email.
Yep. Mine's be up a little bit.
And Steve Sorrell, I'm going to copy and repaste it again since it got kind of archived here. If anybody wants, I'm also going to send an email out with the contact information for those that couldn't make it tonight, such as David and David, who are traveling, and one is flying back from North Carolina. Guys, these are the best guys. I've filtered through, like I said, kissed a lot of frogs to find the princes so that you don't have to do so. I think the same holds true for a lot of the lessons that we teach in this class. Steve, Jaron, thank you so much for your time.
Thank you. Thank you. I just want to make the comment that I have not kissed Marshall. Just so you
know. we have not kissed, and we spend a lot of time together, but no.
Thank you, everybody, for having us, and this has really been great. And Jerome, thank you. It's really awesome doing this with you.
Absolutely, Steve. Great. Thanks, everyone. Appreciate it. Alex, Eton, Marshall, great seeing you.
Likewise. I'll see everyone at the next meeting in a week.
Thanks.
Take care.
Take care.
Bye, guys.
Bye-bye.